shake it up. Check yourself, you can have it all. Oh, vanity, you can have it all. I don't see different kind of love, so I know if it's real enough. Yeah, 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 yeah. I don't go where no love, where my home. Caraibo, down Soweto, long, long way. Wala wala la, wala umbala, wala umbala, owaza baja umbala, oyo oyo oyo, owaza baja umbala, oyo oyo oyo, oh Lord. I don't go where no love find my way. Caraibo, down Soweto, long, long way. Oh Lord, oh Lord, lies one big road. Oh Lord, along the road, down Soweto, Caraibo, Caraibo. La 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 la. Let's go away in the night when the lights out. Let's go away to an island far away. You and I, we will live here together. You and me, my forever. Aye, 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 aye. Plenty fish and banana. I will be your Mayana. Aye, 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 aye. Nothing but our love. Nothing but our love. Nothing but a smile on your face, 'cause we know say nothing but our love. Nothing but our love. Nothing but the love when we give, 'cause we know say we'll never make it. Them say, but our love will never fail. Damn shame, damn shame. We will live here together, you and me, my forever. Aye, 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 aye. Plenty fish and banana. I will be your Mayana. Aye, 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 aye. Nothing but our love. Nothing but our love. Nothing but a smile on your face, 'cause we know say nothing but our love. Nothing but our love. Nothing but the love when we give, 'cause we know say nothing but our love. Nothing but our love. Nothing but the love when we give, 'cause we know say.
Hi, good evening once again, and thank you so much for joining us. My name is Saki Sosi, and I'm in part one. I'm just facilitating this session. I have no right to be here for starters, but my role will basically be to facilitate this session and then also, just setting up this platform so we can all join and benefit from this session. I'll still be glad if I could get some thumbs up if I can be heard, if I'm audible enough. But thank you so much for joining. And the whole idea, like I said earlier, is to create this platform where we can all benefit from information from individuals who have already charted this path before. And that's basically the idea. There's been a session like this for part 1, and there's a session like this for part 2. We're streaming on YouTube, and so the recording will be available on YouTube, so we can all benefit from this session. I mean, I'm told a lot of part 2 students are in a tutorial of some sort, and so this recording will be made available to them so they can also benefit from the session. At this juncture, I won't be talking further. Our speaker has already joined us. He's a very, very good friend of mine, very smart guy by all standards and by every metric of the word. At this juncture, I would want to invite Benedict Niajay Kraku to share with us some of the tidbits and the tips that he has regarding navigating the part 2 examination. And so thank you so much for joining, and thank you very much, Ben, for joining us. I believe we can start now, Benedict.
Okay, thank you very much, Theophilus. Am I audible?
Yeah, I can hear you. I believe we all
Okay, all right. I'm going to take that as an indication that everyone else can hear me. Am I supposed to put on my video, or you guys are okay not see my ugly face?
We want to see your fine face.
Okay, all right. So we'll just take it from there. Right, I'm coming. Sorry, give me a minute. Yes, that's it. Okay, thank you very much. My clerk is helping me set up, so if you see me moving around, that's the reason why. Okay, so I think first off, I'd like to say congratulations to everyone that's on this call. Presumably, almost everyone on this call, if not everyone, is in part 2. So congratulations for making it to part 2. It's not an easy thing to make it to part 2 in the Ghana School of Law, because I started a journey with some people, and some of them are actually still even in part 1. So it's not an easy thing to make it this far. And then Theophilus, I think on behalf of everyone, I would say thank you to you for setting this up. I've known Theophilus for a very long time now. I think about 10 years. We met on Kwabuche Hill somewhere 2009. In fact, at the time we met, Theophilus was the one who was interested in being a lawyer, and I was interested in being a doctor. But some way, somehow, I ended up being a lawyer. Theophilus rather read science for some weird reason, and I read general arts, and then I became a lawyer. But thankfully, the Lord spoke to him, and he's back on the right track. So we just zoom straight into what we are supposed to do today. So basically, the outline of what we're going to do today is we're going to talk about some general strategies to approach the exams, the part 2 exams. Then we're going to pick each and every course and then talk about some specific strategies that would help you for those particular courses. So for those who have not started learning especially, that's the part of the session that would really concern you or be really interesting to you. Then we'll have some miscellaneous things that we'll look at. So things such as pupillage, life after law school, a couple of things like that, depending on how long everything lasts. So straight away, some overall strategies. For me, what I think is that if you make it to part 2, in my opinion, it means you're doing something right. So your first strategy is to analyze yourself. What worked for you in part 1? What didn't work for you in part 1? And logically, what you're supposed to do is maximize what worked in part 1 and minimize the things that didn't work. But then there are a couple of rules of thumb that helps everyone. The first thing I would advise you to do is to read everything. Don't punch as much as you can. Try not to punch. Read everything, because the questions can come from anywhere, and that is the truth. It can come from anywhere. And the thing about the part 2 exams, I think that makes it more precarious than the part 1 exam is that with part 1, you can make it to part 2 if you feel about 2 courses. With part 2, if you feel even 1 course, you're not being called to the bar, you have to do a special call. That's even if you pass the exam later on. So as much as possible, you want to make sure that you are hedging your bets. You're making sure that you are more likely than not to pass. So that means you have to minimize punching as much as possible. But secondly, and more importantly, you should solve a lot of past questions. So for me, my personal experience, I never liked solving past questions. In my 6 years of legal education, I have no recollection of ever taking a look at past questions, but they work. Because whether, I don't know if I should say it's out of habit, but the IEC exams tends to follow a particular pattern. So what that means is that if you solve past questions, especially if you're looking at the marking schemes, you are greatly improving your chances of passing. And the point is how you need to look at the exam is you are trying to answer as many questions as you can to score at least 50%. So anything that's going to boost your chances of getting that 50%, you need to do it. So the first thing you need to do is to read everything. Once you're done reading, the next thing you need to do is to answer a lot of past questions. You can do them side by side. How so? So maybe you pick a topic, you are done with it, you find all the past questions relating to it, and then you solve it. Or you can do what I normally would have done if I was to read past questions. I would read everything, then I'll pick the past questions, put myself in an exam scenario, and then solve it. Because it's not just about knowing the answers, it's about also finishing on time. So as much as you can, test yourself with the past questions. It's very important. Another rule of thumb you should probably consider is answering questions chronologically as much as possible. If you're answering question 1, question 3, question 4, question 5, as much as you can, answer it in that order. Here's the reason why. Your numbers are increasing. We have so many people writing the exams these days. What that means is that when you don't answer questions chronologically, you are giving the examiner more work because he has to keep flipping in terms of the marking scheme that he has to be able to follow what you are doing, especially if it's someone that is really following the marking scheme. So as much as possible, you should make work easy for the person. I'm not saying if question 2 or question 3 is not very good for you, by all means, you must answer that second. That's not what I'm saying, but as much as you can, try to answer that chronologically. The next thing that you need to note is your manuals. The manuals are very important, and they are like a very good starting point in knowing what you should read and what you shouldn't read, or the kind of cases that they'll be expecting to see on the paper. So if you have these rules of thumb in your mind, you have a very good foundation towards getting that 50% that we are all looking for. Now, this is the interesting part for those of you who have not started learning. For those who haven't started learning like myself, I used to actually, I used to start reading very late. So this, I think from here on out, this is for those who have probably started reading it. So let's take interpretation. So with the interpretation exams, it typically consists of 6 questions, right? And you are supposed to answer 4 out of those 6 questions. Question 1 tends to be compulsory. That's the truth. Question 1 tends to be compulsory. You are supposed to answer any 4. The 4 of them are weighted equally. They usually have equal marks. But here's the trick to interpretation. More often than not, and I repeat, more often than not, there would probably be one question on non-statutory interpretation, or at least, let me say, at least one question, because typically you get more than one, but there'll be at least one question on non-statutory interpretation. There'll be a question on statutory interpretation, or at least a question on statutory interpretation. There'll be a question on constitutional interpretation at the very least. Like I said, all of these are at least a question. If you read these 3 topics, you are looking very good in terms of getting your 4 questions to get your 50 marks. So what are you supposed to know under each of these topics? So under non-statutory interpretation, normally the question will come as probably a will or a contract. And then they'll probably ask you to interpret a provision of that will or contract. Occasionally, it might be an essay or a legal opinion you're supposed to do, but the rules don't change. mainly you are supposed to have your binding and binding in your mind and its associated cases. If you have your binding and binding in your mind and the associated cases, some marking schemes also have marks for the more recent marking schemes, I should say, have marks for students that answer those questions using the MOPA, but the locus classicus is binding and the cases that are related to it. It will also do you a lot of good to look at the Wales Act, because sometimes there are some questions that require you to have some specific knowledge about the Wales Act you are bringing into the exams. I'm making this distinction because sometimes the question will be asking you maybe a statutory interpretation question, asking you to interpret a provision of the Wales Act. But under non-statutory, when you're dealing with a will, sometimes it may be necessary to use a provision of the Wales Act to interpret that will. For example, they give you a question. Let's say I'm married, right? Because, and let me look at who's on the call. Let's say I'm married to, okay, there's a participant called Stephanie. So let's say I'm married to Stephanie. Somewhere along the line, after my marriage, Stephanie, I draft a will. Okay. Then in my will, I say I devise maybe my 3-bedroom house to Stephanie. Or in fact, I don't say Stephanie, to my loving wife. I leave it ambiguous like that. At the time of making the will, the person I had in mind. Sorry, is that a question? Hello, Cindy. All right. Okay. We're proceeding then. So as I was saying, with the example I was giving, I'm married to Stephanie. As I'm married to Stephanie, I enter into I draft a will. In the will, I have a provision that says I'm devising a particular property, a 3-bedroom property to my loving wife, Stephanie. Let's say after making that will, I get married to a different person. I divorce Stephanie and I'm now married to Ikea Usua. Or even better, maybe I have 3 children at the time I make the will. Ifia, Ahmed, and Susi. And I say I devise my property to my children. At the time I made the will, I was 3 children I had in mind. But at the time of my death, I had maybe 5 children. And they're asking you to interpret that provision. Obviously, you would need to bring a provision of the Wills Act that says that wills are generally what ambulatory to answer that question, that it would cover all 5 children, even though at the time I made the will, I had only 3 children. So sometimes you may be required to bring in some specific knowledge from the Wills Act, so you may want to also look at that. You would also want to look at the aids to interpretation of non-statutory documents. So under that, for example, for the internal, you need to look at the effect of the operative and non-operative part. So like, what's the effect of a date? What is the effect of a recital? What is the effect of a heading? These are things that you probably have to have in mind. And if you have these things in mind, you are more likely than not to be able to answer a question on non-statutory interpretation. So with regards to statutory interpretation, normally the question would be pretty straightforward. It would be a problem question more often than not, which would require you to interpret a statute. Sometimes it may be a legal opinion, sometimes it may be a memo to a judge, sometimes it may be something that is a case that has been heard and is going on appeal. You're supposed to do written submission, or probably it's the same thing. The first thing you need to know as regards statutory interpretation are the basic rules of interpretation. So you need to have your MOPA in your mind, literal rule, mischief rule, all those things. You need to have all those things in your mind. Also pay close attention to the linguistic canons. So Igestem Generis, Nocita Associis, Expressio Unius. You need to take note of all these things. And also for statutory interpretation, you need to also look at the internal and external aids to interpretation. So similar to what you did under the non-statutory, you would look at things like what's the effect of a heading, what's the effect of a schedule to a statute. You look at things like what is the effect of a provision, a proviso, basically things like that. You need to have all those things in mind. Sometimes some questions would also border on the Chieftaincy Act, sometimes Armed Forces Act. So it may also serve you well for those of you who have not started learning to also look at some of these things, because it greatly increases your chances of getting your 50%, which is basically what we are looking for at this point in time. Because for law school, it's survival first, then enjoyment, as I always say. If you get a 50% and you are out, then you can start worrying about whether you're getting an award or not. The next thing is constitutional interpretation. What should you probably look out for? So with constitutional interpretation, the examiner expects you to understand specifically how the jurisdiction of the Supreme Court is evoked. So you look at things like Article 130, Article 21, cases such as Ex parte Aposa, Ejean Pofo, more recent cases like Nobocor, and then you can even look at the recent case, Abdullah's case, the one on the E-level, stuff like that. You can look at all those things. Then they would also expect you to know issues relating to capacity in terms of who can sue. Basically the same cases, essentially the same provisions, but you need to look out for those things. They expect you to know, because sometimes they would give you a question where it will just relate to interpretation, like whether the courts is probably seized with jurisdiction in terms of the facts that you've been given, or whether a particular person has capacity. Then obviously you have to look at the rules of constitutional interpretation. That's something you'd have to look at. And in recent times, there's been, should I say, a lot of cases relating to the doctrine of political question, directive principles of state policy, mootness. So you may want to also look at that, because that's also part of the scheme that you're supposed to know. At least at the time I was in law school. I don't know if it's changed now, but these are things you're supposed to know. And there are a lot of cases on it in recent times. This doctrine of non-justiciable political question and all those things, you need to look at it, because it's come in the past, and because it's part of the topics that is dominating the legal sphere right now, something you may want to look at, because it can easily come. So when you have these three areas looked at, more often than not, if you take a look at the past questions, you can get 4 questions, sometimes 5. Then beyond that, you now start looking at the other questions. So this is for those who are reading late. At the very least, you need to read these three key areas. Then you can now start looking at other areas like repeals and retrospective legislations. You can look at presumptions and all those other topics. So in terms of recommended reading materials, you can read Bimpom Buta, you can read Sir Dennis, and I'm told, I'm reliably informed that in recent times, some of the lectures like using AZ. Personally, I used Bimpom Buta and then the manual, and those two were good enough for me. So you can also consider those books, but also pay. I don't know why today I keep saying play instead of pay. I apologize, but pay close attention to your manual. It's very important that you pay close attention to your manual. Manual is always a foundation, and for interpretation, for me, I think it served as a very good foundation before I went to read anything else. Because one thing I have noticed in, like, should I say, about 5 years now, more recent times, they tend to follow the manual as much as possible because of the complaints that people had in the past about questions not being in the syllabus and all that. I think IEC is doing a very good job these days of following the manual as much as possible. So if you can, please use the manual as your foundation material. So advocacy. So advocacy is interesting because there's a practical aspect to advocacy. So basically the course is divided into 2, as you may already know. We have the advocacy part, and then we have the legal ethics part. Now the exams will be in 2 forms. You'd have a moots, actual moots, and then you'd have a written exams that you're supposed to do. We'll come back to the moots. Let's focus on the written exams for now, but the moots is out of 30. We'll come back and talk about it. Let's focus on the written exams. So the written exams would typically have 6 questions. Question 1 is typically compulsory, and question 1 would be a legal ethics question. Normally, there will be a problem question usually, and then you're supposed to raise and then resolve the issues. Typically, there'll be at least 12 issues that you're supposed to find. So with that, your ability to answer that depends on how much reading you've done, because you need to read the Legal Professions Act, you need to read the GBA Code of Ethics, amongst other things. Here's the key tip I'll give you for that. First, know the rules. That's the truth. First, know the rules. Know so that when you see the question, you know this is an ethical violation. Even if you don't remember the provision that governs it, at the very least, you should be able to raise the issue analyze it and conclude. And then I'll beg you as much as you can, if you don't remember the provision for this part, please don't guess. If you don't remember, just raise the issue, resolve it, and then move on. So you have a very long, for this particular question, it will be long-winded. It will be the longest question you would have on the paper, sometimes a page, sometimes 2 pages. And they'll just tell you random things. You have to keep looking out for anything that will be an ethical violation. So maybe they can tell you that Benedict has set up his law firm in his house. So already that's like a red flag. You have to start thinking, because you know under the rules, you generally can't use your private residence as your law firm unless it's well divided. So you are looking out for stuff like that. I'm less than 7 years at the bar. I'm taking pupils. You're looking out for things like that. I have a friend maybe called Maxwell, and then I tell Maxwell to go out and then advertise me as the best lawyer in Accra. You are looking out for some of these things. If you remember all the provisions across all the enactments, list all of them. If you don't guess, because this carries the most marks. It's 28 marks, if I'm not mistaken. And that is the should I say, the substantial part of the written exams. And the last thing you want is for someone to mark you down because you cited the wrong provision. So as much as you can, know the ethical rules. If you have time, make sure you know the provisions relating to it too. I can't overemphasize it. Now, the other questions, the 5 other questions would be on the advocacy aspect, and you're supposed to answer 3. With that one, honestly, just read everything, because it's not a lot. It's listening skills, writing skills, what it means to be a good advocate, etc., etc., etc. The manual on that is superb. The manual is very good. The manual is very good. You can also read His Lordship Nana Megache's notes, which we had available in our time. I don't know if it's still available, but it's just like the manual, but it further elaborates beyond what the manual does, and it's very good. As much as you can, in my experience, from what I've noticed, with advocacy, stick to the manual as much as possible. In fact, in my opinion, if you can, give them the exact examples that were in your manual. Give them what is in the manual as much as possible, because over the years, for some reason, a lot of people seem to fail advocacy, and it seems to be coming from the written aspects. And if you think about it, advocacy is pretty straightforward. So I don't know why, I've not done any analysis as to why students tend to fail the advocacy, because I'm almost 100% sure it doesn't come from the mooting. So what this means is, just as much as possible, follow the manual. So get Nana Megache's notes if you can, His Lordship Nana Megache's notes, or you can just stay with the manual. That's fine. Also, focus on questions that deal with who a lawyer is, and then the liabilities that attach to a lawyer. It normally comes. These, like whether the person is a lawyer, sometimes they'll give you a scenario where the lawyer doesn't have his practicing license, stuff like that. All those things, the Section 8s, the Section 9s. Take a very good look at those ones, because they tend to come a lot. Now, the moots. I wish we could have a whole session on moots. That's the truth, and I don't know if I'm the best person to teach mooting to someone who has no prior experience with mooting, because I did a lot of mooting in school. So I may take certain things for granted, because I did mooting across all my 6 years. So I may take certain things for granted. But for moot, what I'll tell you is that in my experience, especially with the law school one, you need to know your law. That's the starting point. They'll give you the question before exams. Normally, the moot will take place after your written exams. You need to know the relevant law that governs the moot. I mean, as a lawyer, that's your starting point. Secondly, you need to know the weaknesses of your position, because as much as possible, the questions will be done in such a way that will be balanced. There'll be an argument, there'll be a place where your argument will be weak. You need to know it, because that is where the judge is going to ask you questions on. As an oralist, it's important that you know your legal arguments front back. Some people go and then they know I'm arguing this first, this second, this third. And the minute you ask them a question, they fumble. You need to know your arguments to the point that if you start and the judge says, I don't want to hear this particular point, I think is a given. Address me on this. You'll be able to move easily and start addressing the judge on that point. Because what wins you marks in a moot is your ability to answer questions. A lot of people think it's just coming to rattle or something. No, it's your ability to answer questions. Secondly, you need to talk slowly. Personally, this is something I struggled with because I talk very fast. I talk very, very fast. So when I'm mooting, I have to make a conscious effort to slow down because you're trying to make sure that the judge understands and buys your argument. So as much as possible, you need to talk at a conversational pace. You don't talk very fast. If your conversational pace is fast like myself, then what you need to do is you need to make a conscious effort to slow down. Another important tidbit for the moot is to signpost your arguments. You're going to make 3 arguments, tell the judge, you're making 3 arguments. First this, second this, third this. It's very important. And as much as possible, be respectful during the moot, be respectful to the judge, be respectful to the person you'll be mooting against. And as much as you can, even prepare with the person you'll be mooting against. Because for me, for example, I was lucky enough to be mooting against my roommates. So for some weird reason, because we were in Kumasi campus together, ordinarily we wouldn't have, because it's done according to names, but because we're in Kumasi campus together, even though our index numbers were far apart, we're close enough on the Kumasi list. So we did a moot together. So we used to practice together in the hall. We would do the research. We both did our research together. We both practiced together. So Calvin Makwe and we helped each other a lot. And I think our moot was really interesting, was really nice. At least a few people that came to watch did say that, although I must say he has some prior moot experience, so maybe that's also played a role. So with advocacy, like I said, focus on Nana Megache's notes as much as you can, if you can find it. And then you should also look at the manual. So family law. With family law used to be a huge problem in the past. I'm not going to mention names. I'm not going to mention why I think it was a problem, but it was a problem. But these days it's better because a lot of people used to fail family law in droves. So with family law, you're going to have 6 questions. You'd answer 4. It's basically the format you already know. Question 1 is typically a petition. Do not enter that exam room if you do not know how to draft a petition. And the petition, it has a settled form. Read it and just go and then draft it. Question 1 would typically be a petition. So you just read it and then you go and draft it. In order to pass family law, essentially, this is what you're supposed to know. They expect you to have a very good understanding of the 3 types of marriages. So marriage under the ordinance or ordinance marriage. They expect you to have a good understanding of marriage of the Mohammedans, what we colloquially call Islamic marriage, and then customary marriage. So you're supposed to know what they are. You're supposed to know how they are contracted or what makes them valid. You're supposed to know the incidents of each of these 3 types or their characteristics. So you know that if you're married under customary law, it's potentially polygamous. If you're married under ordinance, it's not. If you're married under the Mohammedans, it is potentially polygamous, but then there's a limit to how many wives you'll be able to marry. You need to know how all these marriages are dissolved or come to an end, and you need to know the registration. Just by knowing these things, you more often than not have at least 2 or 3 questions ready and set on the paper to answer. Because if you think about it, you realize that if you look at the scheme of work, essentially it's just the things I've just talked about is basically what makes up the majority of the scheme of work you're supposed to know. So like I said, you should have a very good understanding of these 3 types of marriages. Another important thing that you should also look at is things like adoption. Questions tend to come on adoption and then spousal property. With spousal property, you need to be able to trace the evolution of the law, how the law has changed over the years with substantial contribution and then whatnot. With family law, personally, I read Madame Frederica's book. It was very good. In fact, let me share some personal experience. So I started reading family law very late. I started reading family law about 3 days to the exams because I was doing a lot of things when I was in part 2, combining so many things. And I just read Madame Frederica's book. And then at the end of the book, she had a number of questions, I think about 10 questions. So I read a book. I read very fast. That's one thing I'll say. So me reading 3 days to the exams is not exactly strange. Normally what I used to do is I would read, and like I said, my roommate and I, Calvin McQuay, would both meet in our hall. Then we just discuss everything from beginning to end. And if normally he likes to look at past questions, so he might tell me, oh, maybe in Pigeon, I saw this past question, and then this is basically how the marking scheme also looked like. So that also used to help. But like I said, I read Madame Frederica's book, and then she had about 10 questions at the back of the book. In my time, 3 of those questions dropped. So, and she has actually answered the questions. The question, it was word for word the exact same question. So for me, family law, I had 3 questions already breathing and then waiting. And that's excluding the petition. So it's, for me, Madame Frederica's book really helped, but a lot of people tend to read Affair, and Affair is also very good. But I think she also has this white book that has cases in it, other cases. You should also look at that. And you may want to also look at your lecturer's notes, because with family law, back in the day when I used to compare, there used to be a bit of differences in how the lecturers would treat it across the 3 campuses. So it's something you should look at. But if you read Madame Frederica's book or you read Affair, you should most likely be fine for family law. So conveyancing and drafting. So conveyancing and drafting, the course is divided, as the name implies anyway, into the conveyancing aspect and then the drafting aspect. You have 6 questions you're supposed to answer for as usual. My time, question 1 was compulsory. I don't know how usual that is, but typically I think question 1 would be compulsory. Now, here's the thing about conveyancing and drafting, and I'll share my personal experience also with you. Please focus on the drafts. That's the truth. Draft as much as you can, like draft. And I'll talk to you about how you can come up with a good strategy for drafting. So like I said, the course is divided into the conveyancing bits, which maybe I'll say the reading aspect of it. And then there's the drafting bits, which is, as the name implies, drafting. Now, if you look at the past questions, over the years, most of the questions are drafting questions. And a draft is a lease, an assignment is an assignment, a will is a will, a vesting asset is a vesting asset. If you can draft these things and draft them very well, even if you've not read much of the conveyancing aspect, believe you me, you are more likely to pass. And this is what actually happened to me. So for me, like I said, I don't look at past questions, so I did not know this. And then I spent so much time reading the conveyancing bits. And then when it came to the drafts, I made the mistake you should never do when it comes to conveyancing and drafting, and I punched. I read a couple of drafts. I've forgotten what, I think I read a contract of sale, an actual conveyance, an assignment. I think I just went to the exam with about 4 of the actual drafts we're supposed to read. But I'd read everything in terms of the conveyancing bits, because I tend to like analysis. I don't like things that are roots, what you'd call chewing. So I didn't really focus on that bit. And for someone who has limited time, that wasn't really a very good strategy for me, like I thought. And then when I go in and I open the question, it's 6 drafts. Every single question was a drafting question. The only question that had a conveyancing bit was a B, and was 5 marks. I think elements of a trust or something like that, just for 5 marks. Luckily for me, question 1 was a contract of sale, so I had 1 in there. I think question 6 was a contract of sale again, so I had 2. And then there was an assignment, and then I think there was a sublease we're supposed to draft. All I'm just trying to say is that tend to draft. So what I advise you to do is that Hello, Sosi.
Benedict, we lost you for a moment. Are you okay?
Yes. For how long? What's the last thing you heard?
You're talking about the drafts.
I was telling you about my personal experience. I don't know how much you heard, but that's fine. Even if you didn't hear it. The more important thing you should note is this: when it comes to the drafting, I advise you to divide the week into 2. On 3 days of the week, learn a new draft. So let's say this week you are learning how to draft an assignment. 2 days in the week, practice something you've already drafted. So maybe you are drafting a list. So let's say week 1, I've already learned how to draft an assignment. Practice it Monday, Tuesday, Wednesday. Thursday, Friday, learn how to draft a list. The following week, what that means is that Monday, Tuesday, Wednesday, you are drafting with a list. Then the Thursday, Friday, you are learning how to draft something new, because conveyancing is one of the easiest courses to pass. Josephine, I don't know who that is, but okay, thank you very much. Anyway, so like I was saying, you need to be able to divide the week into 2, like I said, 3 days to do the new thing, 2 days for the old one. So that's basically how to go about it. But every day before you sleep, at the very least, draft something. That's the advice I'll give to you. If you like, that should be the last thing you do before you sleep. You just draft something. So you are done during the day, you have gone for class. I don't know, maybe you are a group A person, go Monday, Tuesday. What you can do is that if you're a group A person, you can do Monday, Tuesday. Then Monday before you sleep, draft what you've already learned. Tuesday before you sleep, draft what you've already learned. Wednesday, Thursday, Friday, when you don't have class, learn something new, learn a new draft. So drafting can actually occur alongside the other things. Then maybe closer to the exams, you are scheduling the conveyancing aspects. The next thing you also need to note is the changes the Land Act has made, right? So there's a new Land Act. So if there are any changes that affects conveyance, these are things that you're supposed to also look at. Is someone asking a question? Okay, so that's basically for the 4 courses that you need to do for law school. So to recap, we started with interpretation, if I'm not mistaken. We talked about advocacy, we talked about family law, and then we ended with conveyancing and drafting. We will talk about pupillage, but at this point, I want anybody who has a question, you can raise your hand, I'll call you, you're on mute, and then I answer your question, and then we take it from there. So there are no questions.
If you're also slightly uncomfortable with asking a question orally, you can put in the chat box.
Yeah, sure, that's fine. That also works.
Classrooms, in libraries, and so you can put your question in the chat box, and then Benedict can also tackle that.
Yeah, that actually also works.
He dealt with the issues regarding the 4 courses, and so if you want to ask a question, you can unmute and ask. If you want to put a question in the chat box also, you can. Thank you.
Okay, so someone says, is there any structure for answering interpretation questions? Okay, so with that question, I think how I would answer it is this. As far as I know, there's nothing unique about interpretation questions. So you'd answer it in the normal way that you normally answer your question. If it's a problem question, I mean, you know that you're definitely applying your IRAP. So it will definitely be IRAP. If it's a written submission, if it's a legal opinion, it still follows the IRAP, just a few minor differences, because a written submission basically is just IRAP. Just a couple of things would change. So sometimes they may just tell you to have quicker answer your question soon. So like I said, if it's a problem question, IRAP. If it's an essay, well, any good legal essay in its introduction would tell you what the writer is going to do and how he's going to do it. And then like what we already know, at the very least, 3 paragraphs. Each paragraph talks about a distinct idea. This is very important, a lot of people miss. Each paragraph should talk about a distinct idea. As much as possible, underline your cases and any statutory authority so that the person can see that you are answering based on the law. It's not social studies you're doing. Your conclusion would basically depend on what the question is asking you to analyze something, or maybe asking you what new changes has come in a particular law. So sometimes you can get a question that says maybe discuss maybe how the Supreme Court has changed the rules relating to its jurisdiction in the case of Moboko, right? So stuff like that, you'll be able to just do that. So that's basically how it is. It's not really much different from what you've already been doing. I don't know if that answers your question. The next question I see is someone is asking if you have to memorize for drafting. Short answer is yes. Here's the thing. If you have a good understanding of the substantive law, you would understand why certain provisions are there. Like, you would understand why. But ultimately, you would have to memorize, because most of these drafts have a settled form. Give them the form and get out. When you get out of law school, I mean, you have more flexibility in terms of how you draft. But as much as possible, the drafts, I forgot to ask you, this is a good question. Please, as much as possible, either you are using the Draftsman, Practical Draftsman, or even better yet, the manual. The manual has sample drafts. Use that as much as possible, because if you compare the sample drafts in the manual to the marking schemes, you realize that it's pretty much the same thing. So memorize that, give it to them, and then get out. When you get out, it's more flexible in terms of you can impose your own personal style on the drafting, if I should put it that way. Okay. Okay, so there's a question that says, can you help me out with differentiating between a lease question and a tenancy agreement question? The person who asked that question, I don't know if you could further elaborate, because I don't know if my answer might be good enough. So if you can further elaborate on the question, because it basically depends on your understanding of the substantive law. If you know what a lease is, if you know what an assignment is, I think you'll be able to tell. So I don't know if you know what a tenancy is, you'd be able to tell. So I don't know if you can help me couch the question better so that we could maybe try to give a better answer to that question, because I suspect this doesn't answer your question. I see another question. If you guys can give me a minute, my laptop is about to go off. Okay, right, so it's charging now. Okay, so the next question says, where the question, for instance, asks you to write your answer in the form of a memo, will the examiner pay attention to the features of a memo? Okay, so I would say it depends on the examiner. There's the reason why. If you look at the past questions, I've never seen marks necessarily allocated for parts of a memo. But if it's a memo, just give them a memo, because you could have a possibility of someone marking your paper and then he has allocated marks to that. So as much as possible, do that, but it's not fatal. If it's a memo and you don't really have the features of a memo down to a T, it's not fatal. That much I can tell you. But as much as you can, these basic things, written submission, it's a memo, it's a legal opinion, you should have a basic idea of how to do them. But it's not fatal in my experience, provided your law and your analysis is right. Okay, someone says, if you're asked a question on spousal property, will it be ideal to touch on how the law developed from where a wife and a child are supposed to help, substantial contribution, and the current position of the law? If you have time, yes, you should. You should. And that's the best way to answer the question. But once again, it also depends on how much time you have, because at the end of the exams, you should have attempted all 4 questions. So you need to know what to write and how to write it. So that, for example, when you are tracing the development, since it's a problem question, I'm assuming this is a problem question scenario asking. With a problem question, if you're in court, you wouldn't trace the development of the law necessarily to the judge unless it was relevant to something. So if the question doesn't implicitly ask you to trace the development of the law, you don't necessarily have to, but that's the best way to answer the question. Just don't dwell on the previous positions. Be quick about it and get to what the current position is. Here's a way the question can actually force you to trace the development of the law. They've given you a question, it's on appeal, let's say. and then the judge ruled applying the old position of the law, and it's on appeal, and you are told to write written submissions on it. I mean, yes, that instance, it will be useful to trace the development of the law. It will be useful to trace the development of the law to ensure that the judgment was per incuriam, because it's relying on an old position, and that position has changed in the current cases like Arthur and all those things. Okay. Is it necessary to memorize? The next question, is it necessary to memorize the rules pertaining to legal ethics? That is, do you have to remember specific provisions? And is it fatal if you can remember the rule but not the provision number? Okay, so as the person, this means you probably missed when we're talking about advocacy and legal ethics. So what we said was, I would summarize, I think after the questions, I would maybe in just a quick summary, just summarize what we said about the 4 courses for those who may have joined late, since we're told that some people were in a tutorial of some sort. So here's the thing, you are supposed to memorize the rules. If you don't remember the rule number, don't guess. That's what I said, and it's not fatal. So in my time, I think there were about 13 issues, if I'm not mistaken, or 12. It's one of them is 13, 12, or it's 20. I'm coming, hold on. You know, advocacy. How many issues are we supposed to raise again? Yes, at least it was between 8 to 12 thereabouts, right? Yes, exactly. So I think about half of my answers didn't have an actual legal provision. Like I knew some of them, I had ideas, like I knew it was possibly this, but I didn't want to guess, because what is fatal to you is if you are guessing, you are citing the wrong provision. So what is important is that you should, at the very least, have the rules in mind, and you should be able to raise the issue and then resolve it accurately in line with the law. That's the most important thing. But yes, as much as you can, try and memorize the provisions. If you don't remember it, once I can't overemphasize this, don't guess. Don't guess. It's painful because when I came out, a lot of my guesses, quote unquote, were actually correct. But then you'd still do well if you are able to identify all the issues. Because I think each issue is about 2 marks or 3 marks, if I'm not mistaken, in resolving it. So it's about 28 marks. Okay. Okay. Maxwell also answers. Senior Maxwell also says it's 8 issues or above. If it's below 8 issues, you're punished. Yes, that's it. Okay. I can't see if there are more questions. Okay, I see this. With mooting, are you required to make references from statutes? Can you use your laptop or your iPad, and do they score you for doing that? Okay, please, as much as, and patience, I've seen the patience, you raise your hand. Please type your question. Please type your question. For those who are unable to type or would want to speak, you can just keep your hand up. If you want to actually speak, you can keep your hand up and then I'll call you and then I'll listen to the question. But because I'm reading now, if you don't type it, I may call you later when maybe your hand has been up for a while. Okay, right. So about the mooting, yes, please, you have to make references to the statutes. You have to make references to the decided cases. And with the mooting, you have no excuse not to do that because you have a lot of time to prepare for it. And don't forget that you are actually appearing before real judges. And these are people that are used to dealing with actual lawyers. I mean, you are lawyers in equity, but these are people that are used to dealing with actual lawyers. And they won't treat it like a moot, at least in my experience. They'll treat it like it's an actual case. And in an actual case, you don't appear before the judge and then you don't rely on legal submissions or legal authorities, if I should say so. So you do have to make specific mentions to it. Can you use your laptop or your iPad? Please do not use any electronic gadget there. It looks very unprofessional. And you need to also understand the system that we are in currently. We have a very, and the fact that this is an exam, because with an electronic device, don't forget that this is an exam. With an electronic device, the impression could be that you are picking something from elsewhere or something. So just avoid it. Just go have your written submissions neatly typed out, have a nice file, put it in it, and then just do that. You won't lose anything for doing that. So as much as possible, don't use an iPad, don't use your laptop. It normally doesn't look very good. And if you have a very strict judge, he most likely won't allow you to do that because this is an actual exams. Okay, next question, let's see. Okay, I think that concludes the questions because I think I'm just
but I think there are a few hands. So
okay, sure. Okay, patience. Shoot.
Okay, so my question is with interpretation.
Okay.
Please, when you are asked interpretation question, how do you go about it? Because I learned that particular question. You need to talk everything about that particular question.
Oh, I understand.
I don't know. How do you go about it?
Is it
It's a major problem for me, seriously.
Yeah, so I now understand. I now understand this question. Yes, so this is something that I also struggled with in school. I think your question is actually specific on statutory interpretation. It's with statutory interpretation that normally you'd used to hear that you should answer, you should talk about everything. Here's the truth. Unfortunately for statutory interpretation, I haven't seen a marking scheme. But let me tell you what I did in the exams. I talked about everything. That is the truth. But I kept it straight to the point and I focused more on the MOPA. So that is what I'll tell you, and it worked. So I've not seen a marking scheme because with these things, you always have to look at the marking scheme and what the marking scheme requires. So with statutory interpretation questions, as much as you can, yes, please do talk about all the rules of interpretation for statutory interpretation, and then you pick those you would apply and those you won't apply. If you don't have time, because it's also a timed exam, please talk about only the relevant rules and then ignore the rest. But in my time, I talked about everything. And most of the people I talked to talked about everything and we passed. So I guess that works. But in your application, you only apply the relevant ones, if that answers your question, Patience.
Yeah, thank you very much.
Welcome. Okay, so I don't see any more hands up. Guys, we've been on this call for almost an hour. It's impossible that these are the only questions that you have. Your lawyers in equity, you should have more questions. You should have more questions.
Benedict, you should probably check the chat space. I think there are
they're new. Okay, great.
I believe so.
Okay, right. So someone says, please, do we all answer the same question, the moot, or okay, sick, or every duo with a different question. So basically, person is trying to ask whether it's the same question throughout or every single person gets a different question. It's in between. The answer is in between the two. So what happens is they would have typically about maybe 4 or 6 problems, civil and then criminal. So they'll divide you guys first into civil, then they'll divide you guys into criminal. So some people will be doing a civil case, some people will be dealing with a criminal case. So there may be 2 civil cases, as in 2 distinct facts, and then 2 distinct facts for criminal. So to give an example so that we all understand, let's say I'm paired with Susie. Susie and I are doing maybe civil question 1. That's what we are doing. There'll be a number of other people that will be doing the same question, maybe about 50 other sets that will be doing that same question. Then let's say we have Seni and then Ikea. So Seni and Ikea are doing maybe civil question 2. There'll be about 50 other sets that will be doing that same civil question 2. Then we would have maybe Wanda and Maxwell. Wanda and Maxwell are doing maybe criminal question 1, and then there'll be about another 50 sets, so like about maybe 100 people also doing that same criminal question 1. Then criminal question 2 would also have a different set, so on and so forth. Yeah, so someone says, you mentioned a case decided by the Supreme Court, Loboko or something. Oh, Nobokor, N-O-B-L-E-K-O-R, Nobokor. So it's one of the more recent cases on the jurisdiction of the Supreme Court. It kind of seems to change the position a little. Came out not long before we wrote our exams, and then we had a question I think our question 6 also was something along the lines of talk about how the Supreme Court's jurisprudence has changed when it comes to something along the lines of, but basically the question was asking us to more or less analyze the old cases and then in light of the more new cases. Another new case was, I think, Osei Boateng versus National Media Commission. So you can look at those cases too. Noble, okay, Noble, I think I've spelled it. N-O-B-L-E, like noble, the word noble. Noble, like the noble savage and Rousseau, those of you like jurisprudence, noble, and then core is K-O-R, so noble core. Right. Okay, and let me see if there are any more hands up. Okay. Right, so maybe we just wait for a minute if there are no more questions, and then I'll just assume that questions for that aspect is done. Then we move on to the next aspect.
Benedict, kindly check the chat box. I think there are some questions in there.
No, as far as I can see.
No question.
If I've not answered your question, please raise your hand or something, because I can't see any more questions. Right, so then we move on. So the next thing is pupillage. Right, this is the most underrated part of the law school experience. In my experience, a lot of people do not think about pupillage. For me, I was thinking about pupillage as early as right after entrance exams. So you have to have a clear plan for pupillage. That's the truth. You need to start early. So when it comes to pupillage, there are a number of things you need to consider. You need to consider what kind of law you want to practice. So someone like me, I've always known I wanted to do advocacy. It's actually what even drew me to the law in the first place, because when I was in Form 1 in Infant Pim School, I met this young man known as Saki Sosi, and he introduced me to debate. And that is how actually I became interested in doing law. So for me, it was really more about the advocacy more than anything else. I've not really liked the transactional sit-down aspect to it. So that's already first thing you need to look at. What do you want to do? Do you want to do in-house? Do you want to do litigation? Do you want to do a mixture of all of them? If you are doing litigation, do you want to do everything? Do you want to do corporate, commercial, stuff like that? Because already with that, you're already whittling down your lists. It's important to have these clear plans in mind, because it's not a good idea to start your practice and then you are now realizing that maybe I should have taken this track or that track. So you need to look at yourself. What are your interests? What are your strengths? And then you start looking at the law firms, go on their websites, see what they do, see whether it works for you. Talk to people that work there, see the work culture and whether it works for you. So you need to start early. You need to go to their websites and they need to see whether they have timelines. So me, for example, when I was in first year, Kimathi and Partners used to have this training program. So I had applied to it. So as of the time I was in part 1, I was already doing a training program with Kimathi and Partners. So that is where I did my 2 internships, right? And because the reason why I did that is because that's where I wanted to work. It was it was something I had already planned, right? So I went early, applied, got in, got used to the place, saw how the place was, so that you would know. And that is what, okay, there's a new question. I would answer that quickly. So as I was saying, because of the fact that that's why I wanted to go, I had started early. In fact, for me, I even had a number of law firms in my mind when I was in my LLB, and I was looking at the kind of people that work there. What do they do? Who are they? What would they look out for when they are employing? Those kind of things. So for me, I was very angry about those things. So like I said, I was with Kimathi, and then when I was in part 2, I actually also started considering other options. So as of the time I was writing my part 2 exam, so around this time, I think ENS had actually started their pupillage applications. So at the time, I think right the day after my interpretation exam, I had an interview with ENS. I think my contract even came, if I'm not mistaken, even before I was called to the bar. My pupillage contract with ENS came even before I was called to the bar. And then I had one with my personal experience. I had one with Kimathi. I thought about it, weighed it, and then I decided to go with the ENS one. So I did my pupillage at ENS. Point is, a number of my mates at the time I already had my pupillage contracts were now actually thinking about where will we do our pupillage and all those things. Because don't forget, the law is difficult. And more often than not, most people are finishing with probably an upper. There are very few people that would. And even if you're a first class student, you should start early, because I'm a first class student, but I started early. So it's not an excuse not to start early. Because if they don't have space, they don't have space. If they have a timeline, they have a timeline. It doesn't matter how good you are. If they are not taking people at that time, they are not taking people at that time, unless maybe you know someone or something. So you need to start early. So in my personal experience, I weighed the two of them, which one I thought worked for me, and then I picked the one I wanted to do. And for me, for a very long time, I actually thought I wanted to do corporate commercial litigation, but I later realized I want to do everything. So these are some of the things you need to look out for. But imagine I hadn't even thought about this, and then I got maybe a contract to maybe go and do transactional law, maybe Bella, and I just pick it just because it's Bella, maybe because their litigation team is full or something. It wouldn't have been good for me. I wouldn't have had that kind of work satisfaction that I would have wanted. So you need to look out for all these things. Start early. Research about the firms. Find out their timelines. Talk to people that work there. What is the work culture? How is it? How is like promotions like how will I learn? How will I develop? Does it fit into the general plan I have for my life? Because some of you are married, some of you are in serious committed relationships. You need to be able to balance those things. Some of you may be single, so you can work crazy long hours. You need to know all these things so that you don't end up in a law firm and then you don't fit. You're not a good fit for them, because they must be a good fit for you, but you must also be a good fit for them. So you need to have a clear idea of what you want to do and then who you are. Someone also asked a question, please, what are your thoughts or experience or advice on pursuing a master's before doing your pupillage? It depends. If you're doing, first off, let me just say this, there's not a one size fits all answer to this question, because I've seen people do both and they've had good careers. I've seen people finish. I even know someone that finished. I had a lecturer I admire, Krishna Nivi. Yeah, at that time, KNUST had this thing where the top 4 students, I think when you're done, as soon as you're done with your LLB, you get the opportunity to do your master's at Fordham. So he took that opportunity and then he did his master's right after his LLB. Then he came back to Ghana, did Ghana School of Law lectures. I mean, he's doing fantastically well. I know someone too that finished Ghana School of Law, did their pupillage, came back to do work, but I think it was a huge learning curve for them, because there's a difference between being in school and in actual practice. And that person was in a fast-paced law firm where you are coming and you're like 1 year at the bind. That's how they're treating you. So, but that person didn't have that experience, so that person struggled. So it really depends on what you want to do and the kind of law firm you want to work at. But it's not a one-size-fits-all thing, I would say. But for most of the top universities, most of the top programs, they would require at least 1 year working experience, 2 year working experience. I mean, I know a couple of people that have gotten into Ivy League schools for their masters that have no working experience, but those are more likely. And I think when you have working experience, you know what kind of masters you want to do and how it would impact you directly. You're not just doing it because maybe I just want to do a master's. You know that doing a master's in A, B, C, D has this particular benefits for me. So I think maybe the summary of my advice is, it depends, but as much as you can, practice a little before you do your master's. But it's genuinely, it actually depends. That's the truth. Next question. Let's see. Okay, so there are no more questions. So like I said with pupillage, start early, do a lot of research, talk to a lot of people, and see what fits you. Like I would also say, I think you should also, one thing you should also look out for in picking a law firm to do your pupillage is also maybe retention rates. Like, these are things you need to have in mind, because some law firms don't retain everyone. So if you are picking a law firm and you know that you want to work there long term, then you may need to look at their retention rate, how long they keep people after pupillage. Another important factor that is overlooked in picking a place for pupillage is how long it takes. So I did my pupillage at ENS. That was for a year. Pupillage there is for a year, actually. At the end of the 6 months, you are eligible for them to apply for your license for you, but you'll still be under training for a year. I think with Kimathi, it's 6 months. So every law firm and what they do, but it's a minimum of 6 months. So you need to know what the law firm does and how it fits into your plan. And this is one of the reasons why you need to start early. Because I remember when I started work, I think about 3 months into work, I had a number of mates that didn't have jobs, like they were still looking because either they were not getting jobs or they didn't like the offers they were getting. You only get the offers you want if you start early. And you'll be able to more or less, if you don't get the offers you want, you'll be able to look at your plan Bs more quickly if you started early. So it's something that you shouldn't underrate. The last thing I'll talk about is your knowledge of the law. So whether for good or bad, the law school is designed in a way that makes us very good test takers, but maybe not necessarily good with our law. But it's something that you shouldn't joke with. Your law has to be good, especially if you're doing litigation or you're going to be working on high value transactions. Your law has to be, because when you come out, your job is to make your seniors work early, make your seniors work easy, sorry. So for me, my job is to make my seniors work easy. How do I make his work easy? I make his work easy by making sure I have a very good understanding of the law. If there's a time where your senior asks you, so Mr. Dodson asked me a question and then I don't have a clear answer to that question, for me, it worries me unless the area is gray. And the thing is that when you start practice, you don't have enough time to now be reading. So as much as possible, this is where you need to start amassing your legal knowledge, because a lot of times you'd realize that the client is talking to you, you have very limited time to take a step and you have very limited time to research. So if you don't even know already that there's an exception to a particular rule, you may make a big mistake and you get embarrassed in court, or you may do something relating to a transaction only for the entire transactional process to come down if it's not spotted early, and it will probably be your fault. So these are some of the things you should look at as much as possible. Please, your law, like read up on it. I've noticed that a lot of people coming out these days, the law isn't really that good because we are good test takers, but we are not necessarily good on our law. So as much as you can, like revise your substantive law, because now essentially you are lawyers. Very soon you'll be coming out. You'll be given legal advice and your advice has consequences, because especially if your senior is busy and there's not a lot of review for your work, it's what you are giving out that's affecting that client. Somebody might go to jail because of you. This is serious matter. Somebody might lose a lot of money because of you. So as depending on the kind of law firm and the kind of transactions you are doing. So that's something that you should really look at it. Okay, there's a question. So the person says, I can't see the beginning of the question, sorry, I can only read. Please, if you're already working before coming to GSL, will it be ideal to do your pupillage elsewhere before coming back to your organization, or should you start at your organization? It depends, like a lot of things. There's not a one size fits all, but here's what I would say. How much training would you get being in the legal department of your organization? The training is not enough, or the training is not good enough. You realize that it's rude. Sometimes you can be in an organization doing your pupillage all right, but all you are just doing is literally reviewing standard form contracts. It's the same contract over and over again that you are reading by. Once you review one, you reviewed, or that might not help your legal development. But I mean, it also depends on what you want to do. That's the truth. Because if you want to, for example, work in that organization all your life, and it's a place that has good job stability, and you don't necessarily, you won't necessarily need those other aspects, that's fine. But it depends on how much training they'll give you. It depends on how you want to treat the law also. But as much as possible, if your organization doesn't give very good training, if it will not affect your job, you can take like a 6 months break, work at a high-paced, high-value transaction law firm if you can get it, and then pick up the necessary skills you can and come back. Because the thing about the law is you always have it for the rest of your life. That organization, you may retire at 60, but at age 60, you may still be working as a lawyer. So as much as possible, prioritize the place that you can learn a lot. That's the ultimate thing you need to look out for pupillage. It's not about the name of the law firm. It's not even about the senior, but it's about how much learning that you can do. So if your organization can give you that, that's fine. If it can't, then maybe you shouldn't do it there. You can go and then come elsewhere. So I was about to mention you. The question says, please, can I start my pupillage as an in-house or must it necessarily be a firm? It doesn't necessarily have to be a firm. I think the answer is the same as the previous question. It's about how much training you can get. And it's about what kind of career goals you have and the kind of law you also want to practice. So weigh these things and then you make a decision as to whether you want to start in-house or you want to start with a law firm. I have mates that started in-house and then now at law firms, and then I have a mate that started in a law firm is in-house now. I have mates that have stayed where they are. So it depends, but it's really about the amount of training you can get, because if you lose that job or you become tired of it and you want to leave, at the end of the day, when you go to that new job, you need to have the necessary skills because they're looking at you. You're a lawyer. So you need to have the necessary skills. So at this point, what you should prioritize at this stage of your legal development is how much training am I getting? Because in about a year tops, you should be able to do everything as regards the field of law that you want to do. If it's transactions, if it's litigation, you should be quite set in about a year. So pick the best place that helps you maximize that. Okay, so let me see if there's any other question. Okay, right. I don't see any other questions.
Yeah.
Yes,
so Benedict,
yes, Theophilus.
Yeah, I think it's been a fantastic session, but I'll be glad if you could say in 5 minutes, go over the matters regarding the exam. If I'm in part 2, I have not started studying, I want to start tonight. How do I pass my part 2 exams?
First, pray to God. But let me be honest with you, by someone like Maxwell, I don't know who else, Wanda, the people that know me, they know I don't start learning early. That's the truth. So you're not in bad company at all. In fact, I remember when somebody saw the flyer, they were like, this guy is going to give you bad advice because he never starts reading early. But like I said, with interpretation, what you should focus on is the fact that there'll be one question, at least one question on non-statutory interpretation. There'll be a question on statutory interpretation at the very least. There'll be at least a question on constitutional interpretation. Normally, you realize that you have about 5 questions, normally from just these areas alone, before you even look at the other ones, repeals and presumptions and all those things. So if you've not started learning, start learning those topics. Then you add the rest, the presumptions and all those things. You can add on when you are done with these 3 key ones. So with conveyance, and what we said was practice. Practice the drafts as much as you can. The more you practice the draft, the more likely you are to be able to reproduce it accurately during the exams. And most of the questions would be the draft. So those of you, my boys and girls who don't read early, those of us, the last minute people, that we pray to God that will pass, please, as much as you can, the drafts, don't joke with it. You focus on the drafts. I would even like it if you focus on the drafts, and when you are done, you now go and then start reading the conveyancing bits of it, because if you look at that, you can take a look at the past questions. Most of the questions tend to be on drafts. There are so many years where if you didn't even know anything about the conveyancing bits, you still pass because you'd have about 5 questions. And I shared my personal experience where because I like reading a lot, I like analysis. I'm the jurisprudence kind of guy. I did more reading because I was like, the drafting is true and poor, and I was making all sorts of nonsense arguments. So I wasn't really reading the drafts, and it was 6 hot drafts waiting for me. It was just by God's grace that the ones I chose to read were the ones that had come. But I just kept asking myself, what if they were different? Because it was 6 questions, and they were all drafting questions. It was only one question that had a B, which was on conveyance, and it was the elements of a trust. I remember so clearly. Painful thing was for 5 marks, and I spent so much time reading the reading aspect. So you should consider that. Then with family law, essentially what we said was that if you look at family law, the way the syllabus is structured, it's really just structured around mainly the 3 types of marriages. So marriage under the ordinance, marriage of the Mohammedans, which we call Islamic marriage, and then the customary marriage. And what I said was you need to know what they are and how they are contracted, what makes them valid. After the people enter into the marriage, what are the incidents of that marriage? As in, what are the characteristics of that marriage? You need to know that. You need to know how those kind of marriages come to an end. You need to also look at things like the registration. So normally when you look at that, you realize that you've covered a lot of the syllabus already. The other thing you said for family law is that question 1 tends to be a petition. Do not enter that exam if you cannot draft. Like you might as well just wait and then write it next year if you can't draft a petition. And the petition has a settled form. So just look at it. Where you are supposed to particularize, maybe unreasonable behavior, give the particulars of it. If it's desertion, you give the particulars. There's a settled form. Madam Frederica has one at the back of her book. You can look at it, but it's the same thing. In fact, it's even in practice, you see, it kind of follows a settled form. What normally goes to paragraph, it's always almost the same. If I was to draft a petition and let's say Theophilus was to draft a petition or Senior Maxwell was to draft a petition, it would probably be almost the same thing. So it has a settled form. So you need to look at that also before you now start looking at the other topics. For those who are reading late, before you now start looking at adoption, the spousal property, the domestic violence aspects to it. Then with advocacy and legal ethics, I don't know where you should start from, but this is what you really should know. Like we said, the question 1 would always be a legal ethics question, and that's 28 marks. And then we have the advocacy bits. Those things, they are honestly, for me, they were very easy for me to read. Personally, I think if you are serious, you can use about 3 days, even less, because if you are serious, you can use about 2 days to sit down, read that and revise it. So especially if you've started late, for you, this is when you now need to really sit down and because those things are 14 marks each also. And honestly, it's the same thing. Reading skills, writing skills, what is a good lawyer, those things, types of clients, it is what it is. And they are very easy to read and understand. There's no law. So it's basically like social studies. Take your time, read those things. It's 14. You can easily score 10 or 12 on those ones. Then at least you try and get half of the legal ethics. Because if you are starting late, it's more likely than not that you are not scoring everything on the legal ethics. But that's fine, actually. At least score more than half or at least half. And how do you do that? You do that by being able to identify all the legal violations or the ethical violations that have occurred. So if you cannot memorize the sections, that's fine. But at the very least, you should be able to see that this set of facts have been given. This is unethical. This is unethical. This is unethical. This is unethical. Then you raise and then you resolve it. Okay. What are the 3 areas? So there's a question. What are the 3 areas in interpretation you spoke about? Statutory, non-statutory, and constitutional. I hear it's on YouTube. So for those of you who missed anything, you can just go in and stream because I gave a more in-depth analysis for all the things I just talked about. There's another question. Please, how do you manage intimidation and bullying by seniors at firms? This is a very, very serious question. And this tends to happen a lot in a lot of law firms. So here's the thing. You are less likely to be bullied if you know your law. That's the first thing you need to know. Because most of the time, the bullying and the intimidation normally comes when maybe your law, you're not on top of your game. Because if you're on top of your game, you are less, unless the person is just naturally a distasteful person. And because we are lawyers, you see, the truth of the issue, sometimes I understand some of the seniors that may not come across in the best way, in the sense that the profession is stressful. That's the truth. A client is stressing him. His senior is stressing him. And then he brings it out on you. So sometimes, I mean, if your law is good and the person realizes that consistently, the person is more likely to maybe not bully you, but if it happens consistently, depending on the level at which it's at, talk to the person, talk to your senior about it, because a lot of times you realize that the partner in the law firm doesn't know that these are what senior associates or associates are doing to pupils. So as much as you can, talk to someone, either talk to the person himself or talk to someone above the person to explain it to the person, but be careful and mindful about how you also report it. Be careful and mindful, because it's a work environment. This is somebody you still be working with. So don't burn bridges. Find a nice way. You can even talk to the senior yourself, that, oh, senior, and sometimes you talk to me this way, and maybe I would appreciate it if maybe you'd communicate to me this way or stuff like that. So you have to find a diplomatic way around it. But this is a very serious problem that happens in a lot of law firms. I have mates that sometimes tell me that they cry in the office. And I mean, it's a profession. You shouldn't have to sit in your law firm and cry because someone spoke to you in a way that you didn't want. But these things happen. So Senior Maxwell, since you're on the call, you work with the bar president, and you guys have assured us that junior lawyers will be well taken care of. So Senior Maxwell, please note some of these things. I think it's a very important question. Okay. Please should, interesting question. Please should remuneration be one of the important factors to consider when looking at your options for pupillage? I feel like no matter the answer I give, I may sound hypocritical, because I read that places that's paid well. So I don't know if I'm the best person to say what I'm about to say. It may sound a bit hypocritical, but no. It is an important factor. I mean, you are working to have financial freedom, but it shouldn't be your most important factor. It is important, but it shouldn't be your most important factor. Because the thing is, I don't know to what extent, there's something I want to say, but because of touting, I want to talk about my law firm, but I don't know to what extent that might be like I'm advertising, so I wouldn't. But I wanted to share a personal experience with you, but never mind. But important thing is, summary of the answer is, it's an important factor. Shouldn't be your most important factor. Your most important factor is how much you can learn. Because believe you me, if you are able to learn, go to a law firm where you're able to learn, the money will come. The money will come. That's not to say that in the big law firms, you won't learn. I learned everything in big law firms. I did big law for most of my career so far. So you will learn. But there are small firms that may not necessarily pay you well in the beginning, but you will learn a whole lot and the money will come. So that's really how the profession is, because if you are good, the money will come. Then the next question is, please, for the moods, do you have to meet your colleague? Yes. Yes. Is someone speaking?
I think someone was trying to say something.
Yeah, I think so.
If you're trying to ask a question, kindly feel free to come back and then ask your question. I think it was just probably feedback from someone whose microphone was on.
Okay, sure, then that's fine. So the next question was like, please, for the mood, do you have to meet your colleague on the other side so both of you can discuss what you'll be doing in court? It's advisable to do so. You don't have to, but it's advisable to do so. And that's what I did. Well, for me, I shouldn't say that's what I did as though I went to look for him, because we were sharing a flat together. We're in a 2-bedroom apartment together. So we literally used to meet in our hall, and then we would just bounce ideas off each other. I'll do the research, he'll do the research. I'll tell him, Charlie, my thing, what I realized that this is the weakness of my argument, or this is the case that said it. He'll be like, okay, this is what I found for you. We essentially helped each other because we both wanted to pass. So, I mean, yes, as much as possible, you should do that. It helps both of you have stronger, better arguments. And the thing is that if you are seen to be responding to each other, it makes the mood also nice, and should I say and it's also much more easier for the judge to follow than somebody's arguing somewhere, another person's arguing somewhere, especially if you are the defendant in that case, because you have to engage the arguments. So especially if you are the defendant, for you, chase the plaintiff as much as you can, or you are an accused person, if you can, as much as possible, chase the person who will be representing the Republic, the Attorney General in your case, as much as possible. Okay.
All right. Benedict, I believe we can wrap up.
Okay.
Yeah, we've done an hour and 30 minutes.
Yeah, I think that's been a very long session.
Yeah, and
I tried to talk very fast because I didn't want it to be this long, but looks like we spent a lot of time.
Yeah, and I mean you've been very audible also. But I want to say thank you so much, Benedict, for the information that you've shared today. I mean, I'm sure those on the call are very, very grateful for the information that you've shared and the guidance that you've given. And I also want to say thank you to everybody who's joined us this evening. We are very grateful that you joined. We're streaming live on YouTube, and so the video would save automatically, and then we'll send the link around. And once again, my name is Saki Sosi, and this has just been to help all of us. We're all helping each other. The aim is to make sure that as many people as possible, all of us get the opportunity to get to the bar, and so. Thank you so much for joining. I see someone saying thank you. This was very helpful. We're very grateful. We'll send the link out so you can forward it to your friends who also couldn't make it for one reason or the other.
Yeah. Anybody?
Thank you very much. Thank you very much.
Welcome. You're welcome, David. Anybody else who has any other questions? You can contact Sosi. He would help liaison, and then you can ask if you're unable to ask. If you have any other questions moving forward, you can. Liaison with Sosi. He would give you my work number, and then you can send me a message, and then we'll just deal with that.
Definitely. So you can get in touch with me. We're circulating the messages. You can get in touch with me by anybody who was probably circulating the message. I'll also put my, let me just put my number out there so that everyone in the meeting can probably get in touch. It's 0502110943. Out there. So then get in touch with me, and then if you have any questions for Benedict, I would find a way to get him in touch with you. Thank you so much. Thank you. I can't emphasize my gratitude for you, Benedict, and to everybody who
Theophilus, definitely for you.
yeah. Thank you. Thank you so much. And have a good evening, everyone. I'm sure we'll meet some better time at some better place. Thank you.
Okay. Good night, everyone.
Thank you. Good night.